Have you heard about the term alternate dispute resolution? So from the term itself, we can understand that it is a different way. That is, it is different from the traditional way, which is regarding dispute resolution. So normally we approach a court for dispute resolution. So in alternate dispute resolution, we use another way for settling our dispute. In India, the modes of alternate dispute resolution include arbitration, negotiation, mediation and lok adalat. In this video, our focus is on mediation. Why? Because there was an article in today's newspaper that the Parliamentary Standing Committee on Law and Justice has made some recommendation to the Mediation Bill of 2021. Before getting to the video, this is Fatima Nusrin and welcome to Ekam IAS. So first let's start with the mediation. Let's see what is mediation. Mediation is a voluntary process in which the parties try to solve their dispute with the help of an independent third party or a mediator. The mediator does not impose a solution on the parties but create a conducive environment where they can come to a common conclusion. The mediation process depends on the choice of the parties and there are no strict or binding rules for the procedure of mediation. The advantages of the mediation are: it is voluntary and it saves a lot of time. It is confidential, it speeds up the process, etc. And also it reduces the case burden of courts. Now let's see the highlights of the mediation bill. One of the highlights of the bill is that it helps the people to settle their civil or commercial disputes through mediation before approaching the traditional courts. And if a party wants to withdraw from the mediation, they can withdraw after 2 mediation sessions. The mediation process must be completed in 180 days, or if the parties felt that it has to be extended, then they can also extend again for 180 days. The bill also seeks to establish a Mediation Council of India and its function is to register the mediators and also give them proper training. The bill contains lists that are not fit for mediation, such as criminal prosecutions or disputes that affects the right of a third person, etc. And this list can be amended by the central government. If the parties agrees, they can appoint any person as a mediator. If not, they can approach a mediation service provider for a mediator. The agreements made as a part of mediation is binding as well as enforceable. Now let's see the present condition of mediation in India. The first one is court referring. That means the court can refer for mediation under Code of Civil Procedure of 1908. Then the private parties under a contract having mediation clause. Then any laws such as Consumer Protection Act, if they specify for a mediation, then mediation can also happen. So these are the 3 situations where mediations are currently happening. Now let's move on to our today's model question. It is a 2-statement question. Try to answer this question and write the answer in the comment section below. The answer, the explanation as well as detailed material will be provided in our Telegram channel. The link will be given in the description. And if you find this video helpful, please don't forget to like, share and subscribe. Thank you for watching.